Welcome to CM Guide Podcast Series. Today we're embarking on a deep dive into how construction businesses get paid right here in the Australian Capital Territory, the ACT. Our mission for you is really to peel back the layers of the building and construction industry, Security of Payment Act 2009. People often just call it the ACT Act. Think of this as your essential guide, your shortcut, really, to understanding this critical legal framework. We'll take you from the basics right through to some of the more complex legal bits, making sure you get practical insights, maybe some aha moments, without getting bogged down in jargon.
Absolutely. And just to build on that mission, what we'll really uncover is how this ACT Act sets up a kind of pay now, argue later mechanism. It's designed fundamentally to keep money flowing in the construction industry. Vital stuff. It's really about providing a safety net, especially for contractors and subcontractors, making sure they get paid.
That pay now, argue later idea definitely sounds significant, a real shift. So let's start at the beginning then. What's this act really all about, and when did it actually kick in?
Right. Well, the ACT Act officially came into force on July 1st, 2010, and its core purpose, it's basically to set up a clear procedure for getting progress payments recovered promptly in the industry. It strongly embodies that pay now, argue later principle you mentioned. The goal is to get people paid quickly, you see, even if there are other disputes bubbling under the surface that need sorting out later. Interestingly, it was largely modeled on the New South Wales Act. That was considered a pretty tried and tested legislative framework back then.
Okay, so leveraging what worked next door in New South Wales, that makes sense. Now, are there specific types of work or contracts that are, left out, excluded from this act? I imagine it's not quite a one-size-fits-all thing.
That's a really crucial point, actually, and one that often trips people up. The ACT Act specifically does not apply to construction contracts for residential building work if the party having the work done lives there or plans to live there. So for a typical homeowner getting work done on their own house, this act generally won't apply to that contract. It's a key carve-out. And another important one, the act doesn't bind the Commonwealth government.
Okay, got it. So started in 2010, clear purpose, residential homeowners mostly excluded. But laws aren't static, right? Especially in construction. Has the ACT Act seen big changes or reforms since then? And I guess why the changes?
You're spot on. Laws definitely evolve. And yes, the ACT Act has had some significant updates. A lot of this is driven by a bigger national push for more consistency in these payment laws across Australia. The really big one recently, the 2023 amendments, they came from the Building and Construction Legislation Amendment Act 2023. These changes applied to contracts entered into on or after March 11th, 2024. So fairly recent. And like the original act, these changes were again substantially modeled on recent tweaks in New South Wales from their 2019 changes. It's all about harmonization and stopping really long payment times.
Okay, so more alignment with New South Wales. What are the key practical differences then? What changed for someone actually working in the ACT?
Right. There are a few really pivotal shifts. First, the whole concept of reference dates is gone. Those used to dictate when you could make a claim. Now it's more flexible. Claimants can lodge a payment claim on the last day of the month or an earlier date if the contract allows it. Simpler, less confusing. Second, and this is quite significant, payment claims can now be issued after a construction contract is terminated.
Even if the project stops.
Exactly. So if things go south, you still have a clear route to claim for work done. And thirdly, there's a new standard due date for payment. This is a big one. It's now the earlier of 15 business days after the claim is lodged or the date payment is due under the contract itself.
15 business days. Wow, that sounds like it could really speed things up for cash flow. Does that standardized time frame apply equally to everyone? Head contractors, subcontractors, the lot?
Yes, and that's where we see a really crucial difference between the ACT and, say, New South Wales. In New South Wales, the rules often set different payment deadlines for head contractors paying subs compared to principals paying head contractors. But here in the ACT, that uniform 15 business day time frame applies right down the chain, both head contractors and subcontractors.
So head contractors are under the same pressure.
Exactly. It puts significant pressure on them to have their financing sorted and ready to go because they need to pay their subs just as quickly as they might be expecting payment themselves. It forces a faster, more synchronized payment cycle. That uniform pressure point is definitely something for head contractors to think about. You mentioned a broader national context driving some of this earlier. Can you elaborate a bit? How does the ACT fit into that bigger picture?
Yeah, absolutely. The changes in the ACT really reflect that national conversation, especially following the 2018 Murray Review. That was a major review looking at security of payment laws right across Australia. It made a whole lot of recommendations aimed at harmonizing the laws, making sure contractors and subcontractors get paid promptly, nationwide. Many of those recommendations have now found their way into the ACT's updated legislation, bringing it more in line. And looking ahead, the ACT government is actually planning its own review of these laws in 2024.
Oh, another one.
Yep, findings expected in 2025. It shows they're still focused on improving things, making the industry fairer.
Right, so it's clearly a living piece of legislation constantly being tweaked. Let's get practical then. Say I'm a contractor, I've done the work. How do I actually kick off this process under the ACT Act? What exactly is a payment claim?
Okay, so the whole process starts with lodging this formal request for payment. The Act calls it a payment claim. And for it to be valid, it has to tick some specific boxes. Formal requirements. It must be in writing. It needs to clearly identify the construction work or the goods and services it relates to. It has to state the amount being claimed. And here's the crucial bit. It must explicitly state that it's made under the Building and Construction Industry Security of Payment Act, 2009 ACT. That exact phrase or wording to that effect.
Right, that specific endorsement is vital.
Absolutely vital. Without it, it might not engage the Act's protections.
Okay, so I've drafted my claim, got the magic words in there. How do I actually get it to the other party? Are there strict rules on serving it?
Yes, there are clear rules for service. You can serve it personally, send it by post, use fax, or if it's been agreed beforehand, use email. Now, something really interesting and quite unique to the ACT Act compared to some other places is a specific provision allowing a lien on unfixed materials.
A lien on materials not yet installed.
That's right. If a progress payment is due, but it hasn't been paid, the contractor might be able to exercise a lien over any unfixed plant or materials they supplied for that specific job.
Wow, a lien on the actual materials. That sounds like pretty direct leverage. Does that mean the contractor can just, take the materials back if they don't get paid?
It's definitely a powerful tool, but it comes with an important qualification, a caveat. This lien doesn't automatically create rights against a third party who might actually own those materials.
Yeah.
And crucially, it doesn't take priority over any charges or security interests that already existed on those materials before the payment became due.
Ah, okay.
So if those materials were financed, say, or already secured against a loan, that prior claim would likely trump the contractor's lien. It's more of a strategic nudge, a way to encourage payment, rather than an absolute right to seize the goods over everyone else.
Got it. A nudge, not necessarily a full takeover.
Yeah.
Okay, so what happens if the claim isn't paid, or if there's a dispute about the amount? How does the Act provide that quick resolution we talked about, keeping that pay now, argue later spirit alive?
Right. If a payment claim is disputed, or maybe the respondent that's the party receiving the claim doesn't provide a payment schedule, which is their formal response outlining what they intend to pay.
Okay.
Or if they do provide a schedule but then don't pay the amount they scheduled, then the claimant can kick off the adjudication process. This brings in an independent adjudicator to review the dispute and make what's called a decision. It's important terminology in the ACT. It's a decision, whereas in places like New South Wales, they call it a determination. Subtle, but different.
So an independent adjudicator steps in. How quickly does this happen? Is it designed for speed?
Very much so. Speed is key. The adjudicator has to make their decision within just 10 business days after they receive the respondent's formal reply, the adjudication response, or 10 business days from when that response was due if one is not provided. Now, here's another interesting point of difference, especially compared to New South Wales again. Respondents in the ACT actually get a bit more time to put together their adjudication response.
Oh, really? How much more?
They get 7 business days after receiving the application itself, or 5 business days after getting notice that the adjudicator has accepted the job. Compare that to New South Wales, where it's typically more like 5 and 2 business days. So respondents in the ACT get a little more, breathing room to prepare their case, even within this fast-tracked process.
That extra time for the respondent is definitely a notable distinction.
Interesting. And what about serving the application? Does the claimant have to handle all the notifications? The claimant serves the initial application on the respondent, yes. But once an adjudicator accepts the nomination, it actually becomes the adjudicator's duty to serve that copy of the application on the respondent.
I see.
So that takes a bit of the procedural burden off the claimant once the adjudicator is formally involved. It streamlines things a bit.
Okay, this sounds like a really rapid process overall, aiming for quick decisions. But what if there's a serious issue? a major mistake maybe in the adjudicator's decision. Can these decisions be challenged in court? Or is the adjudicator's word pretty much final under this system?
That really hits on the core tension, doesn't it? Balancing speed with legal oversight. The pay first, argue later policy is strong. Even the risk that the claimant might become insolvent usually isn't enough reason on its own to stop them getting the adjudicated amount while any appeals are sorted out. Cash flow is paramount. Now, what's really striking about the ACT Act is Section 43. It contains an express prohibition on judicial review.
A prohibition, so no court challenges.
Well, it says courts generally don't have jurisdiction to set aside an adjudication decision just because there might be an error of fact or law on the face of that decision. This is a major difference compared to some other Australian security of payment laws. It really limits the grounds for challenging the substance of the decision in court. The message is sort of fight it out in adjudication because court challenges are tough.
Wow, okay. So the courts are intentionally kept out of the merits, mostly. But is there any way for a court to intervene? Is the door completely shut?
Not completely shut. There's a critical exception. Despite that prohibition, the ACT Supreme Court does still have the power to grant what lawyers call prerogative relief. Think of things like certiorari.
Certiorari.
Yeah, it's essentially a court order used to quash or invalidate a decision made by a lower body, like an adjudicator, but only if that adjudicator made a jurisdictional error. A jurisdictional error means they acted outside their legal power, beyond their authority.
Okay, like what?
For example, if it turns out there wasn't even a valid construction contract between the parties. The whole act depends on a contract existing, so adjudicating without one would be acting outside jurisdiction. That's an error the court can review. And there's another unique feature in the ACT. The Act provides an express right to appeal an adjudication decision directly to the ACT Supreme Court, specifically on a question of law.
An actual appeal on points of law.
Exactly. This is quite different from just challenging jurisdiction. It allows the court to look at whether the adjudicator applied the law correctly. But it's not automatic. You need either the consent of both parties or you need leave, that's permission from the Supreme Court itself.
Okay, so you need permission from the court for a legal appeal. What makes the court grant that permission? I assume it's not just for any little thing?
No, definitely not. The bar is quite high, similar actually to getting leave to appeal an arbitration award. The court needs to be convinced, firstly, that deciding this legal question could substantially affect the rights of the parties involved. It has to be significant. And secondly, there needs to be either a manifest error of law, something really obvious on the face of the decision, or strong evidence of a legal error where deciding the question could significantly add to the certainty or development of the law. So it's reserved for genuinely important legal issues or clear mistakes.
Right, makes sense. If an appeal is allowed and successful, what can the court do then? Do they just throw out the decision?
They have a few options. They can confirm the original decision, they can amend it themselves, or they can set it aside entirely. Quite often, though, what they'll do is remit the decision. That means sending it back.
Back to the adjudicator.
Yes, often back to the original adjudicator, or sometimes to a new one, with instructions based on the court's legal ruling. Sending it back to the original adjudicator is usually preferred for efficiency, cost and time savings, as long as there's no reason to think they couldn't reconsider it properly based on the court's guidance.
Right. Efficiency makes sense there. Are there any sort of general legal principles that guide how ACT courts tend to approach these cases overall?
There are a few key themes, yeah. The courts are generally pretty reluctant to overturn decisions unless there's a really clear manifest error that significantly impacts the outcome. That pay-first policy is still very influential. It's also established that claimants can include amounts they claimed previously in a new claim, provided the first one wasn't actually adjudicated. You could even have two claims running. A really critical point is that failing to follow the mandatory steps and timelines in the Act, that is considered a jurisdictional error, which can open the door to that court review we discussed. And while strict issue estoppel, the idea you can't re-argue the exact same decided point, doesn't fully apply to these decisions, trying to run the exact same claim again could be seen as an abusive process. Importantly, just for an adjudicator to even start looking at a claim, it's often enough for the contractor to simply assert work was done under the contract. The adjudicator then digs into whether it was and how much is owed.
Okay, that brings us to the adjudicators themselves. Who are these people making these fast, impactful decisions? And who keeps an eye on them? How does the Act ensure the process is fair and the quality is there?
Right. The adjudicators are independent individuals, yes. And they get appointed by organizations known as Authorized Nominating Authorities, or ANAs. The Act sets up a specific system to regulate these ANAs and the adjudicators. There's a code of practice for ANAs that the minister can approve. It's actually an offense for an ANA to contravene this code. They have to agree to follow it, report if they deviate, and importantly, provide their services efficiently and without any discrimination.
So these ANAs are like gatekeepers managing the integrity of the whole thing. What are their main responsibilities under that code?
Exactly, they play a central role. The code outlines their responsibilities pretty clearly. They handle the whole adjudication application process, the certification side of things. Crucially, they also manage the selection of adjudicators, their training, and ongoing monitoring. They need a quality system in place. And when an ANA nominates an adjudicator for a specific dispute, they have to make sure that person has the right skills for that case, that they've had the proper training, and that any potential conflicts of interest are flagged and managed appropriately.
Okay, so the ANAs vet the adjudicators. What makes someone actually eligible to be an adjudicator in the first place? And are there rules about who can't be one to ensure impartiality?
Good question. To be eligible, an adjudicator needs to be a natural person, so an individual, not a company, and they must have successfully completed a relevant training course approved under the system. So there's a baseline level of required knowledge. As for who's ineligible, yes, there are clear rules to prevent conflicts. For instance, you can't adjudicate a dispute if you're actually a party to that construction contract yourself. Obvious, maybe, but important. You also can't be an adjudicator if you're employed by or represent certain major building and construction industry bodies like the HIA or Master Builders Australia. These exclusions are really vital for maintaining that independence and the integrity of the whole adjudication process.
All right, so wrapping this up, what does this all mean for you listening in? It seems clear the ACT Act is a pretty powerful tool, definitely robust, built on that pay first, argue later idea. It's got unique features, it's constantly evolving, all aimed at keeping money flowing and making the industry fairer. So maybe a final thought for you to consider. Given these ongoing reviews, both nationally and in the ACT, and this strong focus on prompt payment, what could be the next big step, the next innovation in ensuring payment security right across Australia's construction sector? Something that maybe finds an even better balance between speed, fairness, and efficiency.
Absolutely. Understanding these specific ACT rules, their nuances, the recent changes, it's just invaluable for anyone operating in the construction space here. It really is the rule book for getting paid and handling disputes effectively.
Before you go, please don't forget to share, like, or subscribe. Also have a look at other episodes and visit CM Guide website for better insights on this topic.